Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Susan Unagi presenting for us. If you are unfamiliar with the format of this event, first, Susan is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Susan will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Susan to get us started.
Wonderful. Thank you so much, Marissa. Can you hear me okay?
Yep.
Wonderful. All right. Welcome everyone to today's Listen and Learn Child Custody Edition presented by Legal Aid of North Carolina. So let me go to slide 2. So Legal Aid of North Carolina, who are we? We are a statewide nonprofit law firm that provides free legal services in civil matters to low-income individuals in order to ensure equal access to justice and to remove legal barriers to economic opportunity. Notice we said civil matters. That does not mean we assist in criminal law matters. So areas of practice include housing, such as evictions, employment issues, education, domestic violence protective orders, disaster relief, and consumer problems. So we have monthly listen and learns for divorce, child custody, criminal record expunction, tenant rights, Social Security disability, Medicaid rights, SNAP, emergency SNAP, Medicaid eligibility, as well as healthcare, power of attorney, and living wills. If you want any more information on one of these listen and learns, feel free to go on and register at legalaidnc.org/listen and learn. And the link is down here at the bottom, or you can just write that down. So what are we going to go over in this listen and learn? So we are going to discuss the way to file for custody today. Lance does not represent you. This is merely an information listen and learn session. So the intent of this listen and learn, pro se representation, which means when you represent yourself without an attorney, for initial filing for custody and or visitation, applying North Carolina law only. So I can't apply South Carolina law, New York, or any other state, just North Carolina. And this listen and learn provides assistance initiating a custody action. So if you already have a custody action, this listen and learn may not be for you. If you are looking to start the custody process, stay tuned, because that's what we'll be going over today. So again, if you already have a custody case pending or a custody order in place, you may need to file a motion to modify. Information about motions to modify are available upon request, and I will touch a tad bit on those at the very end of this presentation, but not a lot. So feel free to reach out to us for more information. All right, so what area of the law are we going to be talking about today? North Carolina General Statute Section 50 is our custody section of the law. So Section 50A speaks to child custody more specifically. 50-13.1 speaks to child custody and mediation. And so really the main takeaways that you need to know from these statutes are the legal standard for parents in order to show that you should have custody of your children. And that standard is the best interests of the child. Legal standards for non-parents, so either grandparents that are filing for custody for their grandchildren, or maybe an aunt or uncle or non-parent. The standard is to show that the current biological parents of the children qualify as unfit parents. So terminology that we're going to be talking about today and some definitions are plaintiff and defendant. So plaintiff means that is the person who is filing. So if you are the one filling out the custody paperwork and filing it with the court, you are the plaintiff because you are starting an action. Defendant is the person you are filing against. So mom, if you're filing against dad, you are plaintiff, dad is defendant. Dad, if you're filing against mom, dad is plaintiff, mom is defendant. Pro se means that you are filing and moving forward with your case without an attorney. So essentially, you are representing yourself. And then we have primary custody, legal custody, and physical custody. So primary custody, and I'll go over visitation at the end, but primary custody means that you have primary physical and legal custody of the children. Legal custody means that legal custody means that you have the ability to make big decisions about the minor child. So medical decisions, where the child goes to school, religious practices, those types of things. Physical custody means that you have the child with you physically, living in your home. So those are the differences between the two of those. And primary custody just identifies the person that has more time regarding those areas. But a lot of times in custody, you'll see the word joint, meaning each parent has 50-50. So that's what that language typically means. Now, visitation means that, let's say one parent is granted primary custody, meaning that the child primarily lives with them most of the time, and that parent is allowed to typically make the major decisions for the minor children. Visitation can mean the other parent gets to visit with their children for a certain amount of time. It may not be 50-50. It could be every other weekend, every weekend, but that's typically what that means. All right, so who can bring an action for child custody? A parent, a relative, a person, an agency, an organization. When we say agency or organization, we're typically talking about Child Protective Services, or an institution claiming a right to custody, or someone with relationship to or with the child. So it can be a parent, grandparent, aunt, uncle, depending on the situation, as well as Child Protective Services. So where to file? You file in the district court in the county where you reside, or the county where the child and the other party reside. And typically, generally, when you file is anytime after separation. However, in order to file, the child or children must have been a resident of North Carolina for at least 6 months prior to filing for North Carolina to have jurisdiction. And now, if you have a child that's younger than 6 months, the child must have lived in North Carolina for the majority of his or her life. So the best example that I can offer is, let's say you just have a child, and then 2 weeks after having this baby, you move to North Carolina, and you wait 6 months or 7 months. You've lived in North Carolina for 7 months, and you decide, oh, I need a custody order. The place where you're going to file for the custody action is going to be in North Carolina, because for the majority of their life, or for the past 6 months, they have lived in North Carolina. Okay. Now, if you have a 2-week-old and you need to file for custody at 2 weeks, and that baby has been in North Carolina since the moment they were born to that 2-week mark, you file in North Carolina. So parental rights. Until a written order exists, meaning signed by a judge, both parents have equal rights to a child. However, law enforcement will not help you retrieve your child from the other parent unless there is a court order in place specifying them to do so. If your parental rights have been terminated, you do not have a right to sue for child custody. And child support and child custody can be litigated separately. They do not have to be brought under the same action at the same time. So what are you seeking? You can either file for joint custody, meaning both parents share custody, make major decisions. Usually the child primarily resides with one parent, but there can be 50-50. Exclusive custody means one parent has custody. They make the major decisions. The child lives with one parent, but the other parent usually has contact or visitation. And then visitation, again, is when the non-custodial parent, and what that means, if the child primarily resides with one parent, that other parent has the right to see the child. The amount of time is determined on the ages, how close the parents live to each other, and usually is on a schedule. So that's where you hear that language every other weekend, every weekend, those types of things. Now, so before you file, let's say that you know that you need to file for child custody. What do you need? So you do not need to get, what is not needed is child support, welfare assistance, school enrollment, medical insurance, temporary child care. You don't need any of that in order to file for custody. You do need to take into consideration that the filing process can be time consuming. The custody process in general can be time consuming because there are going to be multiple trips that you have to take to court. Something else to take into consideration is that the court does examine your personal life. So they're going to want to know about your employment, your mental health, criminal records, substance abuse issues, character, if you have a significant other, domestic violence within the relationship, those types of things. And if disinterested parents get involved suddenly, the court may make disagreeable orders. So that's all things that you want to keep in the back of your mind when you're getting ready to file. So we always say, do a self-evaluation before you get ready to file, because the court's going to want to know, are you employed? Do you have any pending or past criminal charges? Do you have a driver's license? What's your current living situation? Are you currently homeless? Do you currently have an apartment, a home, living out of a hotel? What's your mental stability? Are there any prior court orders regarding the minor child in custody? And are you looking for custody or visitation? So do you need a lawyer? That's the biggest question that we typically get. And so ask yourself the following questions. Will the other parent be cooperative or will they fight for custody, right? Is the other parent agreeable? Do they agree that y'all need something put in writing in order to follow? Or do you think that they're going to fight every step of the way? Is the other parent likely to get a lawyer? If the other party gets a lawyer, will you be able to get one? Now, you should get a lawyer if your custody case is contested and the other side has an attorney. So what does contested mean? Contested means that the defendant who you filed against either believes they should have full custody or doesn't believe that you should have the custody that you're asking for. Okay. If they get an attorney, you definitely want to seek the advice of counsel. All right. And so, or after reading the entire packet, you feel you need help filing for custody. Maybe you don't fully understand the forms, or you're afraid that you're going to make a mistake or something like that. That would be the time that you might need to hire an attorney. But at least with filing, you can we're going to talk about how you can do that yourself today. And you can always file and seek the advice of counsel later at a later time as well. So, our roadmap for today is we're going to talk about completing the forms, what forms you need in order to file for custody, where to file those forms, how many copies you need, service on the defendant, and then mediation and what to expect in court. All right, so you decide to file for custody. What forms are needed? There's a lot of paperwork. You'll need a civil summons, a complaint for custody/visitation, a domestic civil action cover sheet, a Service Civil Relief Act declaration, Service Members Civil Relief Act declaration, affidavit as to status of minor child, and the optional form petition to proceed as indigent. As you can see on my screen, all of those, except for number 2, the complaint for custody/visitation, all of those have in parentheses a number that says AOC-CV-100 or 750 or whatnot. That means that those forms are available on the North Carolina courts website, nccourts.gov. Those forms can be located there, and we're going to show you where you can find them. But they're not forms that you need to make up or anything. They already exist. They're available to you on the North Carolina Courts website, so you don't have to have your imagination create these forms. Make sure that they are typed or are written in black or blue ink. If they are written in any other color, I have seen clerks tell individuals that they're going to throw them out and that they need to restart or go over it with blue or black ink. You'll need the original and 2 copies of each form. All right. Some counties may require additional forms, so it is important that you reach out to the clerk's office in whatever county you reside in to make sure that you're not missing anything. And you can always visit www.nccourts.gov to access these forms. So this is what the North Carolina Judicial Branch website looks like. If you go to nccourts.gov, you'll see very up at the top, it'll say courts, help topics, services, forms. You're going to want to click on that forms button and it'll take you right to this page. Where it says contains or form number, you can type in AOC-CV- whatever that we had on the other screen, or you can just type in civil summons, domestic violence, or domestic civil action cover sheet, and that form will pop up. And all forms need to be written in English. There are copies that show that are written in Spanish, but those are just so you can compare with the English form to make sure that you understand what they're saying if you are a foreign language speaker. However, they must be written in English. Right now, our courts do not accept documents that are written in Spanish or another language. So first, we're going to start with the petition to proceed as an indigent. So that is form number AOC-G-106. So if you cannot afford the filing fee, this is the form that you use to request a waiver. The filing fee for a complaint for child custody is $150. That's a steep fee. So this might be something you would want to consider. So you qualify to proceed as an indigent if you receive food stamps, TANF or SSI, or if you're represented by like pro bono legal services. If you do not have food stamps, TANF, SSI, or you're not represented by a pro bono legal services corporation or something along those lines, the clerks have discretion to still give you that waiver if you just simply can't afford it. So be prepared to let the clerk know why you're asking for a waiver if you don't have any of those items that we previously listed. And the court clerk will decide whether or not to waive the fee. Now, this goes without saying, but I'm going to say it. Obviously, do not lie. You can be held in contempt of court for giving false information on this form. Contempt means the judge could decide to put you in jail or make you pay a fine. So definitely don't lie. And this form must be signed and dated in front of a notary. You are going to see throughout this presentation that that's a common theme with some of these forms. They need to be notarized. So different counties have different places, different places where you can get documents notarized. If you are in Mecklenburg County, we have somebody at the courthouse. I don't know if that's true for every county court or every courthouse in North Carolina. So make sure you either know somebody or know of a location where you can get your documents notarized. And the cost for notarization, some places may charge $5 per signature. So be prepared to bring cash or a credit card or a card or a check or whatnot in order to pay for those services. So this is what the petition to proceed as indigent looks like. So up at the top where it says state of North Carolina, you're going to see this line, and then it says county. That's where you're going to write the county name where you're filing. So if you're filing in, let's say, Lincoln County, you're going to put Lincoln, or Mecklenburg, you'll put Mecklenburg. On the right where it says file number, do not write anything. You do not have a file number yet. The court will assign you a file number when you go to file these documents, so you're going to leave that blank. However, below where it says in the General Court of Justice, here where it says district, you are going to check that box because remember, we're filing in district court. On this side, on the left, where it says name of plaintiff, you are going to write your name. And then where it says name of defendant, you are going to write the other party's name. Now down below, oops, I went too far. Let me go back. Haha, okay. So down below where it says affidavit, it says either petition to assert claims, petition to file motions, petition to appeal, petition to file expunction petition. You are filing a complaint for custody, a claim. So you are going to check the first box where it says petition to assert claims. Now, down below, it'll say, I am presently a recipient of. You're going to check that box next to that, next to I am presently a recipient of, if you have supplemental SNAP, food stamps, SSI, or TANF. You're going to check any of those boxes that apply. If none of those apply, the next box is I am represented by a legal services organization that has its primary purpose of furnishing legal services to indigent persons, meaning they're representing you for, they're either representing you pro bono or at no cost or low bono cost. If none of those apply, the very last box says, although I am not a recipient of SNAP or food stamps, TANF, or SSI, nor am I represented by legal services, I'm financially unable to advance the cost of filing this action or appeal. That's the box that you'll check if none of those apply. And just remember, be prepared to tell the court why you cannot afford it. Now, here where it says sworn and affirmed and subscribed to before me, that is where the notary is going to sign. You are going to sign on the right where it says date, signature of petitioner. Remember, do not sign until you're in the presence of a notary, but you can write in at least the date and the name and address of yourself. You're the person, you're the petitioner, you're the person that's filing the claim. So you're going to want to put your name and address there. The next form that we're going to talk about is the civil summons. So this is the document that's used to serve the defendant. It's AOC-CV-100. Again, it's another form that you can find on the nccourts.gov website. So this is just talking it out where you're going to fill in certain spots on each document. But under the state of North Carolina, you're going to make sure that you write your county name. You'll provide your name and address as plaintiff. You'll provide the defendant's name. And where it says under to each of the defendants below, if you have one defendant, you're just providing one defendant name, one address. You're not making up somebody else. You're going to write the defendant's name and address. If you are a grandparent and you're filing, or a non-parent and you're filing, you have to list both mom and dad as the defendants. They're co-defendants. So you'll put mom's address on one side, dad's address in the other box. And the civil summons has to be served on both parents in order for you to proceed. So in the box that states name and address of plaintiff's attorney, if none address of the plaintiff, that means you're going to write your name. If you don't have an attorney, you're going to write your name and address again. And we have this form on the next slide. So if you're a visual learner, we'll go through it. You're going to need the original copy that you fill out and 3 photocopies. Now, in some counties, they provide like those transfer sheets. So it'll say that it'll have 2 yellow and 2 white sheets. If there's no yellow paper, you're just going to need 4 copies of a general civil summons. But yellow will be for the defendant, originals for the clerk, the white copy is for you. Again, that's only in certain counties. Otherwise, if you don't have those types of forms at your courthouse, just print off, like type it all in, print off 4 copies. Or print off 1, fill it out, get it copied, or you can print it out 4 times and write it 4 times. Whatever works for you. So this is what this form looks like. So this is the civil summons. You are only filling out the left side of the document. You are not touching the right side, okay? Again, up where it has the line next to county, you're going to put the county you're filing in. We're still leaving that file number on the right side blank because we don't have that yet, but we can check the box that says district. Going back to the left, name of plaintiff, you're going to put your name, your address, your city, state, and zip code. Under where it says versus, it says name of defendant, or in parentheses, defendants. So again, if you're a grandparent filing, you're going to list mom and dad in this box. If you are just mom, you're going to list dad. If you are just dad, you are going to list just mom, and only their name is going to be placed there. You are going to provide their address in the next box down where it says name and address of defendant 1. Okay. Now, let's say you're filing against the other parent, but you know that they have a crazy work schedule and they're not home a lot in order for the sheriff to serve them. What I would recommend doing is writing their name and their home address in one box, and in the second box on the right side, write the defendant's name again and put their work address, because they can be served at work. So that way, if you have the sheriff serve, you have 2 addresses for them to use. Now, down here at the bottom on the left, where it says name and address of plaintiff's attorney, if none, address of plaintiff. Again, you are filing this paperwork pro se. You are acting as your own attorney. So that means your name and address goes in that box. And that's all you're filling out on this page, okay? On the left side, that's for the clerk to fill out. You're not touching that. The clerks will take care of that. Now, the next document that we're going to talk about is the complaint. This is what I would say is the most important document that you're filing here. This is where you're asking for child custody. So there's a sample located in the pro se packet available on the Legal Aid website. It's designed to be self-explanatory. Make sure you leave no blank spaces unless you are sure it does not apply to you. It must be notarized. So there's going to be a page that says verification. That means verification typically means you need to have this page notarized. You are going to need the original copy and then 2 photocopies. Again, what I would recommend is if you don't have a way to type it, print it, fill it out, and copy that. Get 2 copies of that. Copy that twice. Your hand is really going to hurt if you're going to print 3 and write in on 3 documents. So you'll fill in the county. Your name is plaintiff and the defendant's names. In number 1, you're going to fill in the county where you live. On line number 2, you're going to fill in the county and state where the defendant lives. On number 3, you are going to check the box which explains your relationship to the defendant. And then number 4, you're going to fill out the names of the children involved in the case, including their current age and date of birth. And again, we have these forms that we're going to go over for visual learners out there. On line number 5, for each child, you are going to fill out where the child has lived for the last 5 years, including the address, name of the individuals the child lived with, and the current address of that child. You're going to check the boxes, if applicable, concerning any other litigation or lawsuits concerning child custody of the minor. Sometimes we see that one parent that lives out of state filed for custody in that other state. North Carolina, if you're filing here, they're going to want to know that. They're going to want to know that another court has had paperwork filed regarding the children, because then there's going to be a question of, well, which state should this case be heard in? Okay. And then you're going to check boxes if other individuals have custody or claims to custody and or visitation. When we say if other individuals have custody, that's typically, if a grandparent is filing, obviously mom or dad have a claim to custody or visitation. So you would check that box. Line number 6, you're going to select the box that is applicable for custody and or visitation. Number 7, you're not going to touch, leave as is. Number 8 is where you're going to select the appropriate box that shows grounds for proper jurisdiction. Prayer for relief, wherefore. So under that section, you're going to select the box that is applicable for custody or visitation. Do not date and sign the document until you're before a notary. When in the presence of a notary, date and sign the complaint and include your printed name, phone number, and address. That's so the court can get a hold of you, as well as defendant's attorney should they choose to file one. The notary will fill out the information for the verification section. All right, so what does all that mean? Let's look at the complaint. So this is a complaint for custody or visitation that we have available on our pro se packet on Legal Aid website. And so we're going to start up at the top where it says state of North Carolina. Under that, county of, again, put the county where you're filing. I'm going to sound like a broken record, but next to it where it says file number, don't put anything. The clerk will assign that file number. Do not write anything there. Down below, on the line that says plaintiff, you are going to write your name because you're the person filing for custody versus defendant. You're going to put the defendant's names. Next to that, where it says complaint for, and that has 2 check boxes next to custody or visitation over here, you're going to check what you're asking for, either custody or visitation. All right, down below. Number 1, the plaintiff is a resident and citizen of blank county in the state of North Carolina. Plaintiff, you're going to write where you are currently residing. So if you live in Mecklenburg County, you're going to write Mecklenburg. Number 2, the defendant is a resident and citizen of. You are going to put the county they reside in and then the state. So if the defendant lives in Union County, you're going to put is a resident and citizen of Union County in the state of North Carolina. All right. Number 3, the parties are married but living separate and apart, are divorced, have never been married. You're going to check the box which is applicable to your situation. Number 4, the parties are parents of the following children. So this is where you're going to write the name of your children, their age, and the date of birth. All right. Now on number 5, and sometimes you need a couple extra pieces of paper if you have multiple children. But this is where you're going to write where the children have lived for the past 5 years. So during the past 5 years, the minor child, you're going to put their name, born on, list their birth date, has lived as follows. So where it says from and then to, we're going to start now where it says present and work our way back. So let's say, you have a 1-year-old and during that time you've lived in at 2 different addresses. So you're going to look here on this first line. All right. So today, you're going to start at the present time. You're going on the from side. You're going to list where you moved, when the date that you moved into that current residence. If you don't know the specific date, you're going to put the month and the year. So child was born, you're living in Matthews, North Carolina. Let's say the child was born in January, you're living in Matthews, North Carolina. And then you move to Huntersville, North Carolina, when the child is 6 months old. So 6 months, let's say May, June, somewhere in there of 2024. But you've lived at that new Huntersville address from June until now, the date of filing. So here on from, you're going to put June 2024 to present. You're going to list the address where you're currently living, name of the person's lived with, if they're living with mom and dad, grandparents, whoever, and then the present address of that person, which is typically the same address that you have listed under the address box here. Now, before that, if we lived in Matthews, we're going to put June 2024 here, if we're using this as an example, and then we're going to put the date where we were living when the child was born. So like I said, the child was born at that address in January. So under the from box, we're going to put January 2024 to June of 2024. We lived in Matthews, North Carolina, and you're going to put out that whole address, name of the person lived with, mom and dad, and then the names or the present addresses of those persons. So if you've moved around a lot, make sure you think about where you were living, get those addresses. The court is going to want to know all of that information. And obviously, if you need help with that section, please reach out to a legal professional. All right. All right. So next, I have participated in litigation concerning the custody of the above named child. And so you're going to check this box if there has been another custody action brought in a different court. So if you've participated in a custody determination regarding the kids, you're going to check that box, put the name of the court, the case number if you have it, and then the date that the final decision was issued. Second one is I have information of a lawsuit concerning the above named child in a court in North Carolina or another state. That is where, let's say you weren't a party to that case. You weren't a plaintiff or a defendant, but you know that there was a custody case that was determined in North Carolina or another state, like you know it exists. Then you have to check that box, the name of the court, the case number, date of the decision. Again, this goes back to jurisdictional questions. The court needs to make sure that they can hear this case and issue a custody determination. Next, you're going to check, I know of a person listed below who has physical custody, or claimed visitation rights with respect to the above named child, name and address of persons. So you're going to check that box if you know of somebody that has a claim custody right, claim visitation rights, or physical custody. Again, typically this is when a non-parent is trying to file for custody. Those are the boxes that are going to be checked. Second child, you're going to do the same thing. For the last 5 years, where have they lived? Okay. I missed a box here. Nope, I didn't. Yes. Okay. And you're going to answer the same questions as to whether or not you've participated in litigation concerning the custody of the above named children. So same questions as up here. Okay. So going down to number 6, parent is a fit and proper person to have custody of the children. It is in the children's best interest that the plaintiff be awarded. You're either going to check custody, visitation, both, whatever you would like. The parties have been on number 7. The parties have been unable to agree upon a custody and visitation schedule. Number 8. This is where you're going to let the court know that they can hear this case. So the children has or have lived in North Carolina for the past 6 months. If that's true, you're going to check that box. If you are filing on a child that is less than 6 months old, that has lived in North Carolina since birth or for the majority of their life, you're going to check that box. Now down under where it says, wherefore the plaintiff prays of the court, that's the section where you're asking for relief. That's where you're asking the court what you want. So you're asking for an order giving plaintiff either temporary and permanent custody or temporary and permanent visitation of the children listed above. You can check one of those boxes or you can check both. And then number 2, for such other relief as may be proper, just, and lawful. So you're asking for the court to, if the court decides to give you more than that or something else, that it's okay for the court to do so. Do not date and sign, but feel free to put your printed name as well as your telephone number, mailing address, city, state, and zip code. Wait to sign everything until you're in front of that notary for this verification page I'm showing here. This page is for the notary to fill out. All right. But again, where it says plaintiff signature, you are not signing and dating until you go in front of a notary. When you go to have these documents signed by a notary, please make sure you have a valid ID with you. All right. You can't have a photo of your ID. They're going to want an actual photo ID, non-expired, with you. All right. Affidavit as to status of minor child. So this is form, sorry about that. All right, this is form AOC-CV-609. You have to fill out one form for each child involved in the court case. So if you have one child, you fill out 1, 2 children, you fill out 2, you get it. These forms must be notarized. And again, this is where you're looking to where and with whom the child has lived over the past 5 years. I know that you filled out this information in the complaint, but the court also wants it under the affidavit as to status of minor child as well. So this is what the form looks like. Again, we're not filling out our file number. We are filling out our county, name and address of plaintiff, name and address of defendant. Over on the right side, you're going to put the name of the minor child, their date of birth, as well as their birthplace. Okay. And by birthplace, you don't have to provide an address. You can simply say the county and the state where they were born. Down below, you're going to put the history of where they've lived for the last 5 years. Once you have finished filling out this section, you're going to go down where it says, I further say that if you have participated in litigation concerning the custody of the above named child. So if you have been a party to a custody case that took place elsewhere, or maybe even within the same court, you are going to check that box and you are going to fill out the information below. So your capacity as a participant, that means were you a plaintiff or were you a defendant? Were you not a plaintiff or defendant? The date of the child custody determination, so when that order was issued, the case number, the name and address of the court where that case was decided, and any details that the court needs to know. Down below, you'll check that box if you have information about a custody proceeding that you know about regarding the minor children. Examples of custody proceedings include divorce, Domestic violence, a protection order, termination of parental rights or adoption that is pending in this court or in another state. So you'll put the name and address of the court and any details regarding the case. So include a case number, describe the nature of a proceeding. So most commonly, let's say a custody determination was made in a domestic violence protection order matter. You are going to check that box, put the name and address of the court that heard the domestic violence protection order case. You're going to write the case number here and let the court know that custody was determined as part of a domestic violence protection order. The court needs to know that because custody determinations as part of DVPOs are only in place for a year. After that, they expire and you have to file for permanent custody if you want a custody order. So the court needs to be made aware of that. And then down below, I know of a person as listed below who has physical custody or claims to have custody. So anybody that claims to have custody of these minor children, either under a court order or not, you're going to put their name and address and check what they're claiming they have. Down here, sworn and affirmed / subscribe and subscribe to me. That's where the notary is going to fill out their information. Next to that, you are going to fill out that information. Date, your signature, your printed name, and your relationship to the above named child. All right. Next form is our domestic civil action cover sheet. This is basically an information sheet so the courts know what you're filing. They have your information as well as the other party's information. It is AOC-CV-750. That's the form number. Again, under state of North Carolina, write the county where you plan to file. You are going to put your name and address. You will then write the name of the defendant. And you're going to check box yes next to the summons submitted section, and we'll go over the form next, so you'll see what I'm talking about. Under the domestic violence civil action cover sheet, you are going to select initial filing because this is the first time you are filing for custody. You are going to select no next to jury demanded and pleading. Juries are not available nor present in child custody cases. The only person deciding custody is one judge. In the box that states name and address of plaintiff's attorney, if you do not have an attorney, if none, address of plaintiff, again, you're putting your name and address because you're proceeding pro se. Under the type of pleading, we're selecting complaint. Under the type of claim for relief, you are selecting custody and or visitation. You are going to sign and date the form at the bottom. This page does not need to be notarized. And you're going to need an original and 2 copies, one for the clerk, one for you, one for the defendant. And this is what the form looks like. So again, up here, you're going to put the county you're filing in, your name and address, just the name of the defendant. Under where it says summons submitted, you are going to click or check yes. On the left side, you're going under domestic civil action cover sheet, you're checking initial filing. And then where it says jury demanded and pleading, you are going to check no. And then there underneath that where it says name and address of attorney or party, if not represented, you are going to put your name and address. And then put your telephone number down there as well so the court can call you if they need to. Now, we're going to jump down to type of pleading. You're going to find the box that says complaint. It should be the 4th box down. It says complaint. And then claims for relief, you're going to check custody. Again, 4th box down, or visitation, it's the 2nd to last box. At the bottom, you're just going to date and sign. Again, this page does not need to be notarized. Custody mediation cover sheets. So these cover sheets are typically county specific. Your county may not require one. So this is something that you'll want to check either in the local forms of your county or call into the clerk or go to the courthouse to see if there's a specific sheet that they have to ensure that you're using the correct form. This form is used by the mediation office to schedule orientation and mediation session dates. You're going to fill in the relevant information, which may include items such as your name, address, date of birth, phone number, email for yourself. You'll put in the defendant's name, address, date of birth, phone number, and email, whether the parties were ever married, their date of marriage, date of separation, the name, age, and date of birth of who resides with the child and their relationship to you, and then you're going to sign and date the form. So cover sheet for custody mediation. This is what that looks like. So plaintiff's information on this up here on the top half, defendant's information on the bottom half, and then you're going to put your marriage date, or if you were never married, you'll check that, separation date, and then you're going to put the name of the child, their age, their date of birth, the person the child resides with, the relationship, and then at the bottom, you're going to sign. Next is our Service Members Civil Relief Act declaration. So our SCRA is a federal law which protects service members' legal rights during active duty. So it applies to members of the Army, Navy, Air Force, Marine Corps, National Guard on active duty. So the North Carolina Administrative Office of the Courts developed a form for the courts to become informed and to comply with the SCRA requirements, which means that there needs to be a search of a federal website to determine whether an opposing party is an active service member. This form is AOC-G-250. The form can be found here using this link. And then the SCRA, this link down here, the SCRA.dmdc link here can be used to determine the federal military service status of your defendant. So the reason why we need this information is because if there is a service member on active duty, the court cannot enter an order until the court appoints an attorney to represent that service member. And if a party's on active duty, in most instances, the case will be stayed, meaning postponed until a later date. This is to ensure that the orders are not entered against service members who cannot appear due to their military duties. For instance, if they're overseas and can't be present. So if you're filing a new lawsuit in North Carolina, make sure to always complete and file an SCRA affidavit when you institute your action. If you do not file this document, a lot of times these filings are denied by the courts. We specifically see that most often in divorce cases, but also in custody. They will not accept your filing if you do not have this form. So this is what the form looks like. Up at the top, next to county, you're going to put the name of the county you're filing in. Beneath that, you'll put your name and address of the plaintiff. Below that, name and address of the defendant. Now, where it says declaration, all that information below. Number one, as of the current date, you are either going to check A, B, or C. A, I have personal knowledge the defendant named above is in the military. B, I have personal knowledge that the defendant named above is not in the military. Or C, I am unable to determine whether the defendant named above is in the military. Number two, as of the current date, you'll either check I have or have not received a copy of a military order from the defendant named above relating to his state of active duty. Number three, you'll either check you did use or you did not use the Service Member Civil Relief Act website, and the link for that website is listed there to determine his federal military service. If you are going to use the website, you'll want to check the box that says the results from my use of the website are attached. Your other option is to, if you do not use that website, which I would recommend that you do use it, but if you don't, you can write under number 4, the following facts support my statement as to the defendant's active military status. So for example, if you know that the party is not in the military, you'll need to state how you know that. So typically the court is looking for, I have known the defendant for 20 years. I know that they, or I have been married to the defendant, or I was married to the defendant for 20 years. I know that they were never and are still not a member of our armed forces or are not in the military, something along those lines. And then at the bottom, it says, I declare under penalty of perjury that the foregoing is true or correct. You are going to date, sign, and print your name. This form used to need notarization. It does not need to be notarized anymore. It just needs to be dated and signed. Once all these forms are filled out, again, you want 2 copies of, you'll want the originals and 2 copies of each document you filled out. And once you have those, you're going to take those to the clerk's office. The original is for the court. One copy is going to be for the defendant, one copy is going to be for you. When you go to file them, you'll pay the filing fee there, or you're going to ask to have that petition to sue as an indigent be approved. You'll ask that the copies of the summons be issued by the clerk and have the sheriff's fee ready. I believe some sheriff offices do accept the petition to sue as indigent to waive their fee. Not all do, so you'll still want to have that sheriff's fee ready just to be on the safe side, and that is $30 to serve. And they typically accept cash only. Once you file these documents, the clerk will file stamp the copies of the summons or complaint and mark papers with file number. That's where you get your file number. And make sure you save that file number once you get it, because that's how you're going to stay updated on your case. And then it'll be used to identify your case. So if you ever have to communicate with the court regarding your case, they're always going to ask for that file number so they can see everything that's happened in your case. And you're going to want to put that on every document you file after filing for custody, initial custody, because that's how all your documents stay together in the same file. So how to pay. Remember, the clerk's office will not accept personal checks. If you do pay those fees, they must be cash or money orders. Some counties do also accept credit card. Again, if you want that information, make sure you contact the courthouse before you go and file. The clerks are not lawyers, so they cannot give legal advice. Just keep that in mind. Only an attorney can give legal advice. All right. Next step is serving the defendant. So after you file everything and you have your copy that you get to keep and the copy that needs to be served on to the defendant, there are several ways to serve them. You can serve by sheriff, by certified mail, and last resort, publication. You cannot serve the defendant yourself. This means you cannot take a picture of your documents and send them to the defendant, and that count as service. You cannot email these documents to the defendant. You cannot go and hand a copy to the defendant. The clerk will not, or the court will not recognize that as service. They will only recognize service if it's by sheriff, certified mail, or publication. Your case cannot be heard without service. So you cannot move forward until the defendant has been served. So service by sheriff. This is when the sheriff's department goes out and physically gives a copy to the defendant or an individual that lives with them that's over 18. The cost is $30 per defendant. The sheriff's department accepts cash or money orders in the county where the defendant lives. So if you're filing in Mecklenburg, if you filed in Mecklenburg, but your defendant lives in Union County, you're going to have to take that paperwork to the Union County Sheriff's Office and ask for them to serve the defendant those documents. You can mail them. If you're close enough, though, I would drive them. It's just easier and it gives you peace of mind. But also call the sheriff's department where you are needing service to occur to see if they will accept them in another manner. Each sheriff's department is different. So just contact their civil division. You'll give a file stamped copy of the complaint and summons to the sheriff, and the sheriff will notify the court when service is effected, meaning achieved. Some sheriff's departments will tell you that they're going to notify you. So they'll fill it out and they may send it back to the court, or they'll send it back to you. If they return the civil summons back to you, you will then need to go and file that with the courthouse. Okay, so make sure that whatever address you put on your paperwork or provide to the sheriff's department, make sure it's up to date. Make sure it's an address that you typically get your mail and you're not going to forget about it. All right. Another method of service is by certified mail. So if the sheriff is unable to serve the defendant, you can take a copy of the summons and the complaint to the post office. Ask a postal worker there if you're not sure what you're looking for, ways to mail something by certified registered mail, because they'll let you know exactly what you need. But you'll send the documents to the defendant's home address, certified mail, return receipt requested. They're going to give you a certified mail slip and a green return receipt card. We call it the green card. So when the green card will be attached to your envelope. The defendant will sign that green card once it's delivered to them, and they'll give that back to the mail deliverer, and then they will then send it back to your address so you can file it with the court. So once you get that green card back, you'll fill out the affidavit of service by certified mail, attach the green card to that, sign the affidavit in front of a notary, make a copy for yourself, but give the original to the clerk. And so the affidavit of service, what that looks like is this document. So once you have them served by certified mail, you'll put in the county, your name, the defendant's name. Your name will go here, the plaintiff in this action. Duly sworn, depose, and say and certify that a copy of the civil summons and complaint were deposited in the U.S. mail via certified mail, return receipt requested. The same was mailed to the defendant at the following address. So you'll put the defendant's name, address down, and then the date that they were received on. All right. And then this will be signed in the presence of a notary and notarized. So we mentioned publication earlier, and the reason why we don't do a slide on publication is because this is your last resort. So publication means that you can file a notice in a countywide newspaper in the county where the defendant lives, letting them know that a custody action has been filed against them. We say this is the last resort because the court will not accept this method of service if you have not tried the sheriff's department or certified mail first. Notice of publication is used when you do not have an address. You don't have a good address for a defendant. You may not know their address, but you know they live in a certain, they live in that county. So a notice will be placed in the newspaper once a week for 3 consecutive weeks, and then that will count as service. But if you are going to have to use that method in order to serve the defendant, please, please, please consult with a legal professional, an attorney, to ensure that you do this correctly. So after the defendant is served, what next? So once the defendant is served, they have 30 days to answer. What does that mean? They can either do nothing or make a motion for an extension of time, meaning more time to respond to all the allegations within your complaint. Or they can file an answer with or without counterclaims. That means if they file with counterclaims, that means they're also asking for custody or visitation. So if there are counterclaims other than custody or visitation, make sure you consult a lawyer. Like if they're asking for child support or anything else like that, consult with an attorney. The case then is automatically set for mediation. So that's a requirement in North Carolina. If you filed for custody, you have to go to mediation. This typically happens at the courthouse. There's a mediation office with mediators that one will meet with you and the defendant and see if you can work out a custody agreement that you both agree with, then that you both would find acceptable. And the court will provide instructions for you and the defendant. So just keep an eye on your mail as well as your email, because sometimes they will send an email out to you. So specifically, what is mediation? So it's a process in which a professionally trained third neutral party helps parties develop an agreement for the care of their children during and after separation. The goal is to give you an informal forum to discuss parenting issues prior to trial. And typically how it works is there's an orientation session followed by informal confidential meetings with the mediator. The only document that leaves the meeting is the parenting agreement if one is reached through the process. So if you reach a parenting agreement, that agreement can become your custody order and can be signed off by the judge. So here's an example for mediation. These are some standard visitation schedules that you can ask for every other weekend with alternating major holidays: Easter, Memorial Day, Father's, Mother's Day, 4th of July, Thanksgiving, Christmas, spring break, and 4 weeks in the summer. Some parents ask for that. The mediator suggests what to consider in making a parenting agreement. They don't tell you what you should or should not do. They are making suggestions. They're there to help you come to an agreement. They are not attorneys. They cannot give legal advice. So if mediation fails, let's say you go to mediation, you can't come up with an agreement regarding custody. Ask the clerk who is in charge of setting the hearings to give you a hearing date and follow the directions from the clerk. You're going to file a notice of hearing and a civil calendar request. Again, this is different for each county, so make sure you check with your with the clerks to ensure that you're filing what you need to and what you and refraining from filing anything if you don't have to. But you'll serve the defendant with filed copies of both forms. You'll keep track of all dates, and please be on time. Judges hate it when you're late. Be on time. Make sure that you gather your witnesses who can testify as to your ability to care for your child and evidence that supports your claim that you're providing the best home for the child prior to the hearing. All right. So this is a calendar request or notice of hearing. And again, this is different for each county. So make sure you chat with the court clerks. But this is an example of one where you're going to fill out just the caption. And then you'll ask the court for a hearing or trial date. Don't put in any date because the courts run on specific schedules. The court will provide you with the dates that you need, as well as your assigned. You'll know who your assigned judge is, but just don't fill in a date. Let the court do that. All right, so before the hearing, let's say if you want to stop your claim for custody, what do? You file a notice of voluntary dismissal. So a voluntary dismissal stops the entire trial process. You can pick it up for up to 1 year later, but this is an action of last resort. All right, so don't file this willy-nilly. Consult with an attorney before you do so, but this is an option. So preparing for trial. Dress conservatively in professional attire. Don't wear jeans, or leggings, or athletic wear, sweatpants, pajama pants. Don't wear any of that. Wear nice dress pants or a skirt. Make sure that skirt is a little bit more conservative. Just don't show up looking like you just rolled out of bed. All right. Dress in professional attire. Make sure you're on time or even a little bit early. All right. No drugs or alcohol before or during trial. This is a big one. I have been in court when a party has shown up smelling like marijuana. The judges notice. They will call you out on it, and it is up to them to decide whether or not they want to address it, but you could get arrested. So especially if you drove. So please be sure that you refrain from any drug or alcohol use before or during trial. Always tell the truth and try to maintain your temperature and composure. Like, I understand in trial, you're talking about your kids, right? These are the most important beings in your life. And the other party may be saying some not great things about you. Remember to be cool, calm, and collected. Do not interrupt the other party while they're talking. The judge will give you time to tell your side of the story and to address any issues that the other party has brought up during their testimony. You'll want to speak clearly, make eye contact with the judge. Remember, there's no juries in domestic cases. I highly recommend bringing a notepad with you in order to take notes while the other party is testifying. So that way you can tell the court your side of why you want custody, why it's in the best interest of the minor children for custody to be granted to you, and then address the issues that were presented by the other party during their time to talk to the court. And again, do not interrupt the judge. Do not interrupt the other party. That's an easy way to make the judge upset. The judge will give you time to speak. Just be patient. Wait until the judge addresses you directly. But going back, also preparing for trial, we talked about way back at the beginning of the presentation about the standard being the best interest of the child. And so to just give you an idea of what the court is typically considering regarding the best interest of the child. So they are looking at, what does the stability of the child with a parent look like? The parent's employment history, child care arrangements while that parent is at work, conditions in the home environment, whether a party uses drugs that are alcohol, is it consider drug and alcohol abuse? What is the mental and physical health of each parent? Are the parents able to encourage a relationship with the other parent and co-parent? Are there siblings involved? The court will consider the mental and physical needs of the child specifically, or if the child has special needs, religious development, education, domestic violence perpetrated on another parent or the minor child, or child abuse, developmental interests or extracurriculars activities of the child. And in some cases, if the child is over the age of 11, the court may, and I say may, not will, but may, take in what the child wants. But that is typically what the court is looking for. You're not going to go in there and bash the other parent. That's not what's going to happen. You're going to go in there and provide points on those items that I just listed. That's what the court wants to hear. Okay. So after the hearing, the judge may make a decision verbally in court or write out a decision and mail it to you. You will always get, if you're filing for permanent custody, when you get that permanent custody order, the judge will verbally make their decision in court, but you will get a paper copy of that order. It will be mailed to you. Again, a judge's decision is called an order, and you must comply with this order. As it is written, regardless of your feelings about it. If you violate the order, the court can punish you for your failure to follow that order. So it's important that you follow the order. Can orders be changed? Can they be modified? Yes, a temporary order requires a best interest of the child determination. So if you have a temporary parenting arrangement and you're waiting for your permanent custody hearing, and there's been a change, you can file for a modification, and the court just needs to determine if that change, if that modification is in the best interest of the children. However, if you have a permanent custody order, there needs to be a substantial change in circumstances. And to determine whether or not what's going on qualifies as a substantial change, consult with a legal professional. And good luck. So our Legal Aid of North Carolina's helpline is listed here, 866-219-5262. And you can also find us at www.legalaidnc.org. You can also, if you would like to talk to an attorney or try and hire an attorney, you can use the North Carolina Bar Association Lawyer Referral Service. Their number is 919-677-8574. You can also go on their website, northncbar.org. You can get a 30-minute consultation with an attorney for $50. I also know that some county bar associations offer something similar. So if you use the North Carolina Bar Association's Lawyer Referral Service and don't come up with anything, always check in with your local bar and see if they have any resources. But otherwise, that's all I got.
Awesome. Thanks, Susan. I first want to mention that all the links that Susan has mentioned throughout her presentation, I have been posting those in the chat, as well as some information for anyone who has or knows someone who was impacted by Tropical Storm Helene. All through the chat, there are multiple links for things that were discussed today. We do just have a few questions in the chat, just to remind everyone, you cannot unmute in this forum. So if you have a question, you either need to type it in the Q&A box on Zoom or the comment section on Facebook. So starting with our first question, someone's asking, is there any benefit to filing if the other parent isn't, in the picture or involved at all?
So that's really a case by case. Yeah, that's a case by case basis. Like that's a real factual consideration. So if the other parent really isn't involved and hasn't wanted to have a hand in the child's life up until this point, it may not be worth filing for custody, because you don't want to initiate an action and then have them show up and all of a sudden they want to be really involved with this child that they barely know. So I would say, again, it's factually specific, but that's just something to keep in mind, because that's a possibility of something that could happen, is that they could show up, they could get a lot more time with the child than you're anticipating. And you may not get the result you want. So that's just something to keep in mind.
So someone's asking about filing if they don't have an address for the other party.
So if you you do need an address. You can do criminal background checks or a statewide background check. People Finder websites are actually really great. I've found a lot of addresses using those. Even voter registration information online, you can find an individual's address using that. But again, if you don't have an address, you're going to need to know at least a general area of where they're currently living. And that's where we talk about the notice of publication. But you are going to have to try and serve them via sheriff and the certified mail prior to going to publication. So that would be a situation that I would definitely recommend consulting an attorney about. But yeah, you can use those people search websites in order to find addresses. See if you can find one and go from there.
Next question. If there hasn't been a true substantial change in circumstances, can someone still have their custody order modified?
So if you file for a modification and there's a permanent order, there by law there has to be a substantial change of circumstances in order for the court to modify it. If both parties agree and they want to enter into some sort of agreement after somebody files, that's a different conversation. Typically, you'll go to mediation first and work it out there. But if there isn't a substantial change in circumstances, I would recommend do not file for a modification because it will be struck down if it goes to trial.
Perfect. Someone is saying that them and the other parent have an agreement, kind of, but they don't have like an official agreement. Is there still a benefit to actually filing?
So the difference is if you file for custody and let's say you already have a written agreement that you both have been following and want to follow going forward. The biggest difference with an order signed by a judge is if the other person violates that current agreement, then you have legal recourse. So, like for example, if they withhold the child from you permanently, right now you don't have an order that can get that child back. The only way that the police can get them to turn over that child is if there's an order signed by a judge. So you're able to go to the court and get relief if a situation like that were to happen, or if they're violating, they're not following that agreement, you can file for contempt and the court can not force them, but can strongly encourage and issue sanctions against them if they are not following that order. So that normally scares people enough into saying, oh, I better follow this order because I don't want to be found in contempt by the court. So that's really the benefit of having an order. But if you're able to co-parent with just a written agreement, then that's great. And I would recommend, I mean, if you don't need to get the courts involved, don't get the courts involved.
Someone has an order from a different state, but they're looking to file for modification here in North Carolina. Would they still need to attach that order from the other state, or have that?
That order would need to be registered in North Carolina if the children have been here for over 6 months, and that other court is deemed to no longer have jurisdiction. So if that order, you can't file for a modification in North Carolina until that court order has been registered here in North Carolina.
I'm not really sure if this is a question. But someone's asking, is it a good idea to file for custody before a child starts school?
Again, that's a factually specific. Yeah, that's a factually specific question. Really, we can't say when is or is not a good time. It really is a case by case basis. I mean, if you think school is going to be an issue and you need the court to make a determination as to where the child's going to go to school, then go ahead and file. But likely the child that custody order isn't going to be signed before the child goes to school, depending on when you file it, because it takes a while for these things to be scheduled.
And then the last question that I'm seeing here, someone's asking if they can use a motion to show cause to have a permanent custody order modified.
No.
Okay. Okay, well, I am not seeing any other questions, so I'm gonna go ahead and say thank you all to, wait, hold on, I think another one just came in. Okay, that is not a question. Okay, I'm gonna go ahead and say thank you all to all of you for joining us, with a special thank you to Susan. Special thank you to Susan for presenting and for answering all those questions. If you would like to review anything that was discussed today, we have posted a recording of this presentation to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other listen and learns that Susan mentioned on simple divorce, tenant rights, Medicaid, Medicaid, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their day.